Good afternoon. I think we're ready to proceed. I'm Alex Vesselinovitch from the Litigation Practice Group, and with me is David Becker. And we're going to try to cover three actually large topics in an hour. So I hope we're not going to be rushing through, but we're certainly not going to be able to cover everything in great detail, but we'll cover the key points. And the first one that I want to address are the recent changes in the Federal Rules of Civil Procedure. The rules of civil procedure have been around since the late 1930s. They've been changed a few times. And I think in the last 15 years is the biggest change. Change about 7 rules substantively. I'm going to try to address the most important changes. And I'm also going to try to talk about what we don't know yet, because they kicked in for December 15th, 2015. Here we are in August already. And the rules did amend cases that were pending. They're not just prospective. So if cases were pending in December 15th, 2015, they'd also apply to them. So let me address, if I could, the big picture and some of the big points of these amendments to the rules, what they're designed to do. The first thing I think is that they're designed to encourage more active and earlier engagement in the case by the judges. So these rules aren't just designed to put a fire under the litigants or the parties, but actually to put a fire under the judges themselves, recognizing that the judges were sitting around quite a bit, letting things get stalled, letting discovery take too long, letting discovery get initiated too late in the game. They want much more active case management early on. Another thing the rules are designed to try to do is narrow the scope of discovery. Whether that succeeds or not remains to be seen. Lawyers have a great way of getting, not quite around rules, but using rules in a way that makes them as broad as possible. The rules have shortened some key deadlines, especially up front, to get the ball rolling in discovery and in the case earlier on. They've even changed and reduced the time limit to serve a party defendant once a case is filed. They've allowed parties to serve written discovery requests early on, almost immediately. And they've clarified the standards for e-discovery, electronically stored information. I'm going to talk about that in more detail. Did I lose the PowerPoint? Oh, no, there it is. Okay. So some of these points I've mentioned, but like I said, under Rule 4M now, if you want to serve a complaint, you're supposed to do so within 90 days of filing instead of the 120 days. The scheduling conference can be earlier. You can file written discovery requests before the 26F conference. Disputes are designed to be brought in front of a judge live earlier on instead of just having mailing or emails. Rule 16 now encourages live case management conferences or video conferences. It encourages the judges to direct the parties to appear before them before filing discovery motions or disputes. Less mail, more telephone. Less email, more live conferences is part of the design here. And as maybe the biggest change, though, and one of the ones that I really think is one of the big takeaways, is the effort to narrow the scope of discovery under Rule 26. The old clause that was used, and I'm sure everyone's very familiar with who's ever litigated, is whether something was reasonably calculated to lead to the discovery of admissible evidence. That was the old scope of discovery, very broad, very sometimes abused. It would lead to so-called fishing expeditions. The rules are designed to erode that, to make it narrower, and to put fishing expeditions to rest. The old excuses for broad discovery are designed to be narrowed now. And that clause, the old reasonably calculated clause, is out the window. It's been eliminated, and it's been replaced in Rule 26B1 with a new clause saying The scope of discovery must be relevant to the party's claims or defenses and, quote, proportional to the needs of the case. So the real change in the scope is this clause, proportional to the needs of the case. And what does that mean? Well, there's 6 factors, and I went to one of these rollouts for these rules where the rollout was addressed by federal judges who've encountered these changes for the last 6 and 8 months, and they said, the factors are frankly somewhat confusing. They haven't been able to apply them in a rigid way, but they're not designed to be rigid. They're not designed to be hierarchical, and no one's supposed to have the burden as opposed to the other party. So it gives the lawyers, but especially the judges, more flexibility as to which factors to apply. The fact that the factors are lined up in a certain sequence in the rule is irrelevant. It doesn't matter. Each factor can be applied and given the weight the judge thinks it deserves. But I think one of the practical things that the judges, at least in the preliminary impressions are, is that when you talk about a party's relative access to relevant information and a party's resources, they've been applying that more stringently now. They recognize that one side of the case may not have the resources as the deep-pocketed corporation on the other. They recognize that one side of the case may have easier access to certain discovery than the other side, and they're taking that into account. But there's no burden on the requesting party to prove proportionality in advance. In other words, no one has the burden. Each party can make their arguments and counter-arguments on these factors. And the judge has the discretion how to apply these factors on a case-by-case basis. It's designed, one judge said that I heard address, he's saying it's really designed to be a template, just a template for the parties and the judges to look at and to weigh the factors as they think they should be applied. Plaintiff's bar has had sort of a fit on this. Some of the plaintiff's lawyers have said, this is really going to do us harm. This is designed really to make our life much more difficult in getting discovery. Judges have been, at least some judges I've heard, have been pushing back on that. They said that's not the design. That hasn't been the intent. It hasn't been designed to cut out discovery or the scope of discovery to which a plaintiff's bar used to be entitled. It's supposed to cut both ways. So some important points in this slide is that one other change as a practical matter that the rules are designed to bring about are the boilerplate type of objections, boilerplate responses to discovery requests are supposed to be out the window. The design here, the intent here is to say, if you've got a objection, make it specific, don't make it generic. If you are withholding documents, tell them that you're withholding documents. Don't give me the subject to our foregoing objections kind of language. That won't work anymore.
And Alex,
yes.
we talked about this a little bit before the presentation, and both, Alex worked at Catton for years, and I've come up to Freeborn, and boilerplate objections are not things that we had normally filed or accepted from opposing counsel. So this isn't doing something that was completely different. Your lawyers have been doing this all along. The issue that it is now is it's just out. You can't just say it's overly burdensome. I've also never seen a court enforce an objection that just said it's overly burdensome with no reason if they bring it up when you get to the motion. So it's different, but it's not groundbreaking.
Right, and time will tell, frankly, how these proportionality factors are going to be worked out. There isn't a lot of published decisions on this yet. The judges themselves are wrestling with it. But one issue that's a real mystery and is left maybe unsolved by these changes is what about class actions? Plaintiffs bring class action complaints, and let's assume there's a class action complaint brought before the class has been certified. What is proportional there? What is proportional for discovery before a class has been certified? Clearly, there's a world of difference in the scope of discovery if one plaintiff, the class rep, is bringing the case, as opposed to 5,000 people. So the judges even recognize there's a gap, if you will, in how the rules are addressing proportionality for class actions. And that'll be interesting to see how it evolves. With respect to document requests, and I think David hit on this a little bit, but I also just want to say this is also where the schedule's been made a bit quicker, sooner. You can file document requests 21 days after the service of the complaint now, and you can file it before the 26F conference. But you know, practically it may not make a huge difference because you don't have to respond to the discovery request until the 26F conference is held, and that only starts the 30-day clock ticking. I think the concept here is if you're a plaintiff, you've brought the complaint, you ought to know what you want and need really soon. So if you're the plaintiff, the burden's sort of on you to serve, if you want to, discovery requests right out the box. Again, I've mentioned this, but responses to Rule 34 document requests now are supposed to be specific, and you can't sort of give a wishy-washy answer on when you're going to produce documents. You know, I've grown up, if you will, where you just say, we're going to produce these documents, and then you leave it alone. You don't say when, you don't give a specific designated date. Those days may be gone, at least for judges who are going to enforce these amendments. They're going to say, no, if you're going to produce documents, you have to inform the other side when.
Not to interject too much, but
no, please do.
Usually when you get the I'll produce it whenever, the first response when you have a conference is when is whenever. Otherwise, you know, maybe you're going in for motion practice. And again, I just want to stress that a lot of this is just codifying things that people who were litigating, you know, thoroughly previously were already doing. So.
I want to spend a little time on the changes to Rule 37E, and that has to do with electronically stored information, ESI, electronic discovery, because that's been really the colossal headache, I think, in the last 15 years for litigation, discovery, document production. We live in a computer age, we live in an email age, we live in an age where there's hundreds of thousands or maybe even millions of pages of documents sometimes. Complicated IP, patent, other cases have incredibly large amounts and large volumes of ESI that have to be dealt with. So they've amended Rule 37E, and that rule, again, only applies to electronically stored information. It does not apply to tangible evidence. So what they've done is there are split in circuits on what does it take to get punished or sanctioned if there's spoliation of electronically stored information. And the circuits were going back and forth, and they said, let's make this clear. You're only going to get really punished, that is, where a judge can allow an adverse inference to be drawn, if you have intent, if you've intended to spoil the information, if you've intended to damage the electronically stored, if you've had some intent. And only then can a judge impose a drastic sanction on the party for failing to produce or failing to preserve, really, a lot electronically stored information. It was interesting because I heard a webinar just a week ago on some judges who are giving the preliminary reviews, feedback on this change. And at least two of the three federal district judges said that they've noticed that there's fewer disputes now on ESI, fewer disputes coming in, fewer motions coming in on spoliation with respect to electronically stored. The reason for this might be is that if you tie into the change to Rule 16, the case management orders, what the rules are asking the parties to do is to come in with a plan, an agreed plan, sometimes called, I won't use the acronyms too much, but TAR, a technologically assisted review procedure. In other words, we have a ton of stuff on ESI. We've agreed to a technologically assisted review plan with predictive coding and the likes, and we're going to present to the judge, and here's what we're going to do. We have these keywords, we have this format, we have that format, and it has been encouraging the parties up front to come up with a mutually agreed plan as to how they're going to address and how they're going to deal with their ESI. The other thing that is the Rule 16 change is made is that it's encouraged the parties to come in with what's called a Federal Rule of Evidence 502D order. Why? The panic that everyone has when you've got a ton of electronically stored information is that something will slip through the cracks and that something will be attorney-client privileged, something very sensitive like a privileged communication, something of that nature. A 502D order now, which is encouraged under new Rule 16, says the parties can come in by agreement and say, look, if something gets out of the bag and it's privileged, and if it's inadvertent, of course, there's no waiver. It protects the parties from the inadvertent disclosure of the attorney-client privilege email or document that got out of the bag, and it cannot be then viewed as a waiver of that privilege. In the old days, some law firms would fire associates for letting attorney-client privilege documents to be produced. Those days hopefully are almost gone, because now you can come in with the 502D order right up front and say, not only you're basically anticipating the production of attorney-client privilege documents, you're almost expecting it to happen by mistake. But if it happens by mistake, you'll be protected on the waiver.
The combination of the two is actually a really great opportunity to try and lower discovery costs for defendants. If you can make a real assessment as to whether the case you're dealing with is one where there's a lot of information that's really sensitive, like you're dealing with your most important competitor or something like that, then a lot of these things won't be helpful. But if you can determine that this is an individual plaintiff who's not likely to have any use for your secret information, you can put together a good set of terms to apply in one of these technically assisted reviews. You can put together a 502D order. You put those two in place, and you're able to really limit the fact that some poor lawyer is going to have to go through 1 million documents. Maybe you can limit that set down to tens of thousands, and then within that tens of thousands, really only need to review a portion.
The big picture here, I'm trying to make a pragmatic picture from what I hear, is, believe it or not, to make everyone relax a little more, lighten up a little more on the ESI, because they don't have to panic if something gets out the door, and they don't have to over-preserve ESI. They don't have to go overboard in over-preserving it, so long as there's a plan with predictive codes and so forth that's even supported by technologically assisted review. I won't touch on the topic that Todd and Mike Bryan will get into, but one of the things that they will address is how Freeborn has an internal capacity, a very strong capacity to dealing with e-discovery and electronically stored information for its clients, which I think is fairly unique to this law firm. So let me try to wind up the big points on the changes to these rules of civ procedure. Certain things you should know about, because they're important to know that what has not been changed. Number of depositions hasn't been changed. They haven't put any more restrictions on the time or length of depositions. They haven't put any restrictions on the number of interrogatories. They haven't put restrictions on the number of document requests or even requests for admit. Really, those numbers or limitations have not been changed in any significant way. So the takeaways from my point of view for these changes are they're designed to avoid stalling. They're designed to get the case moving earlier with the judge's involvement. They're designed to limit the scope of discovery, try to make it a little more manageable, and to decrease the cost and litigation time of dealing with e-discovery. They're designed to eliminate boilerplate objections and make them more specific. And part of it is to encourage the courts to embrace and use party-agreed approaches to discovery, especially when it comes to electronically stored information.
So now we're going to shift over to topic number 2. Here, I'll take the controller. And now we call them hot topics. I don't know if everybody agrees everything's hot, but the cyber stuff sounds cool. I will get a little bit interactive. For background, how many people here saw the movie War Games? All right, that was hacking, right? Guy gets in the back door of a computer. How many people are watching the show currently on called Mr. Robot? All right, this is a show about a hacktivist. This guy takes down the equivalent of basically ball together JP Morgan Chase, Enron, and everything in one fell swoop. And the objective of that move was to basically cause anarchy. It's scary. And every single presentation I've seen on cybersecurity, cyber technology, cyber litigation, anything cyber starts with be afraid. They all start with that. So I think anybody in this room is probably sophisticated enough to know that computers are a big deal. People can get into your computers. Let's keep an eye on that stuff. But there is a little bit that we want to go through to kind of stress why this matters a lot. So in 2014, there were recorded about 43 million cyber incidents. Now, it's important to distinguish between incidents and breaches. An incident is just, for instance, somebody left their cell phone in the cab, and they need to go to their IT department and say, you got to shut my cell phone off. Okay, if you have an appropriate system in place for your company, all that has to happen is they say, oh, okay, we shut it off, we wiped it clean, no big deal. Now, if you don't have that system in place and that cell phone goes and gets in the hands of somebody else, and you're able to see that somebody accessed secret information, all of a sudden that's a breach. That breach that allowed people to get to sensitive information that might be on your cell phone could be something that implicates an entire cascade of issues for your company, including notification provisions, insurance, everything. So when we're talking about breaches, these charts show what percentage are in different industries. An interesting point here is if you look at the finance industry, only 5.5% of breaches are there. That's where the money is. You'd figure it to be higher. But those companies have spent tons of time and money making sure that they're not open to breaches too easily. So it's a lower percentage. What we're seeing a lot is in business, which is kind of the general catch-all of non-financial commercial entities, and we're seeing a lot in healthcare. Now, when you talk about a breach, it falls into healthcare if HIPAA-related information is getting made available to somebody who's not supposed to have access to it. Breaking it down more in these industries, there were 640, in 2014, there were 642 incidents involving financial companies. Now, that doesn't sound like a big number, but if you look at each of them, you'd say there's going to be a large number of records implicated in each of those incidents. And people who track this stuff have said that the average cost per record that is exposed in these kinds of breaches is $215 a record. Let's say that's 100,000 records. And I'm just a humble lawyer, I don't do a lot of math, but I think that's $21.5 million for 100,000 records. What if it's 1 million records? How big's your bank? How big's your company? So if we look at some other industries like healthcare, the implications here could be as simple as your doctor's office falls prey to a ransomware attack where they get an email that all of a sudden says, oh, if you want to be able to access any of your patient files, send us this amount of Bitcoin by the end of the day in 2 days or we're going to delete all your records. Then you got to figure out how to get Bitcoin, then you got to transfer the money, and most people just pay it. The other thing that's becoming kind of a hot topic is what if you're dealing with medical devices? It's pretty bad if someone's able to hack and hijack a machine that's hooked up to you in the hospital. What if it's the embedded device that's like one of those wireless defibrillators, something like that? So the import of these issues is pretty big. And what are the direct costs to people when they do fall prey to a cyber attack? Now, there's the employee time, of course. There's, that is the time that they're using to figure out how to fix it, how to address the issue. You have technical costs. That could be you have to get a new server because one server got fried in an attack. Notification costs. Now, I want to talk a little bit about notification. Today, there is currently a very jumbled array of notification requirements if your company falls subject to a data breach. Every state has a state's attorney general. Every state's attorney general has reporting requirements. Every state's attorney general's reporting requirements is different than the other states. So, and every state wants to exercise their power as extensively as they can. So you have a data breach in Chicago, but there's data that might implicate Florida. The Florida Attorney General needs to be notified. The Illinois Attorney General needs to be notified. And that's just on the state level. But those questions become very specific and related to each of the breaches. So all I can stress in this point is that's a time where you do need to get a lawyer or have a person internal at your company who's dealing with looking at that. Because I was looking at it while getting ready for this. I received a chart that another firm had made listing all the notification requirements. It was 50 pages long with 6 columns, and it was not fun to try and look at. When you get to the federal level, it's even worse. So the Department of Homeland Security is very interested in getting notifications from people because they want to see if there's a real dangerous cyber attack they need to look further into. And they also want to be kind of the gatekeeper to the rest of the government. That's not really working because all the rest of the government would like to get their fingers in being important as well. So if you're a financial company, I think that well, not a financial company, pardon me. If you are a publicly traded company or a company with investors of any kind, the SEC might want to hear from you. If you are a communications company, the FCC wants to hear from you. If you are a company that is consumer-facing in any respect, or probably even not consumer-facing but does business in any way, the FTC wants to hear from you. And there's no way to be sure any of them got notification, so you just have to notify them all. And once you notify them all, then there's certain other things that will happen afterward, but the main thing is that everybody wants to know, and you can get some immunity from some liability, and you won't get fined, because there are fines that are available out there as well. You can get fined if your data is compromised and you made representations that you were protecting people's data. Now, going through the direct costs, legal costs, unless you have an in-house person who deals with this all the time, you're going to have to talk to someone like me to go through that big chart and help figure it out. Remediation costs, that somewhat repeats what I was talking about, technical costs, but it's also going to be in the case of anybody who deals with electronic payments. They're going to have to deal with credit tracking, people's credit reports. They're going to have to give that service to everybody who was subject to the attack. Some things that aren't on the slide that also can get in there would be the ransom that you end up paying in that ransomware attack. Or what about reputational costs? And on the right side, I question that 1.55 billion number. I would probably ignore that. But the point is that you should think about brand value. So when you look at a publicly traded company that's subject to a cyber attack, your stock may drop a significant percentage point one day. And then 2 days later, it might be back, but in that intervening period, a lot of people lost shareholder value. Now, a lot of this sets up with what I'm going to talk about after Alex has a chance to talk about some of the litigation implications, which is how do you insure against some of these losses? And there is one note that I want to make before I hand it over to him to talk about the case law that's developing, which is does anybody know the average time it takes? I just learned this last week at a CLE I was at with Matt over here. How long it takes for the average company to discover a data breach? 195 days. How quickly do they expect you to respond to it? Like right away. So it's something that can be sort of incipient and going back there, but you need to be ready to deal with it. And I'll talk a little bit more later about the kinds of things you should have in place to deal with it.
If there's any company that keeps on its data customer information, private information, consumers' private information or financial information, they're at risk. They're at risk of litigation and exposure to lawsuits should that information be breached and disclosed. In a relatively recent case in Seventh Circuit Court of Appeals, there was a lawsuit brought against Neiman Marcus, the retail department store group, because people who had Neiman Marcus credit cards, thousands of them, there was a breach of the data base for Neiman Marcus, and their information was hacked for thousands of customers. What was interesting is they brought the suit, plaintiff's lawyers brought the suit for the class against Neiman Marcus on mainly tort principles, things like negligence. If you just talk about negligence for a minute, that suit was allowed to proceed. The Seventh Circuit Court of Appeals said the plaintiffs could go into court, they could make a claim. Don't forget, in this case, Neiman Marcus didn't do anything intentionally wrong. It didn't hack its own database. There was nothing criminal in any of the evidence that came out, but they could be sued, and they were exposed to litigation on a number of state law tort counts for neglecting the security and proprietary interests of the financial data and the consumer information on their accounts. So companies are at risk. The statute that was mentioned, somewhat in passing by Dan Lancelotti in the first section, is something that we want to address a little more, called the Computer Fraud and Abuse Act. The Computer Fraud and Abuse Act is a federal statute. It's a little bit like the RICO statute in this respect. It began as a criminal statute only, designed to protect government computers from hackers. And protected computers were defined pretty narrowly as government-based computers, say like Department of Defense, state, and the like. And then it was amended over the years. It was first enacted like in the 80s. Here we are in 2016, and it's been amended and expanded, and every amendment of that statute has expanded it. And now, and there has been a private civil right of action, just as there is in RICO, for private litigants to bring claims under the Computer Fraud and Abuse Act. The most important thing about this act is to know that it exists and to know that it's a weapon. Many companies are unaware of it. They don't know about it. And so they're running into state court, frankly, when they've been hacked or there's been a data breach, or they know even an employee who has taken or misappropriated their data and run off with it. They run into state court, not realizing all the time that they have a federal option if they want to use it. And it's a very powerful option, and that's the Computer Fraud and Abuse Act. Again, as I mentioned, it used to be limited to protected government computers. Now it's basically applied to any kind of computer that uses the internet. So the expansive nature of this statute has gone into pretty much any computer in the United States. And it has, by the way, extraterritorial application. The government's been using the Computer Fraud and Abuse Act to indict criminally hackers from overseas for years, whether they're in Russia, China, Uzbekistan, or whatever. There's a case called U.S. versus Ivanov, which was the first application of this statute overseas. So they have been indicting people overseas using this statute. But I think, and I get the sense that private companies, corporate entities, have not been using it as much as they could because they're frankly not really aware of it. So I don't want to go through every element of the statute. It would probably take too long, but I want to hit on some key points if I could. The second point is it proscribes obtaining information by means of unauthorized access or exceeds authorized access. The second clause there is important because what that's been interpreted to mean is if you have an employee in the company who has authorized access to the computer, but that employee abuses that access or exceeds his or her authority on how to use the database, there's a cause of action there.
Hey, Alex,
Yeah.
I think this is the one we talked about
Yeah.
in the prep. So if you have an employee who's getting ready to go and leave the company and compete, so this kind of relates back to what Rachel and Dan were talking about, and right before they leave, they download a program from the internet to wipe out the USB log on their computer so that you can't see if they've accessed that USB drive anymore. Is this something you could use?
It's something you could very probably use in that situation. There was I think the short answer would be yes. There's a recent case where someone left a company. They were locked out of their computers, which is the appropriate thing to do, but then they used a friend's login credentials who's still at the company to continue getting access to the company's database and to use it through using a buddy's login information. That was viewed as prohibited under the Computer Fraud and Abuse Act because, again, they were exceeding their authorized access. So, I mean, the other thing is, of course, it prescribes any use of computers by anyone, pretty much, employer or otherwise, even if they've authorized access to it, even if they have every right to be there, if what they're going to do with the information is to perpetrate some form of fraud, or if they have some fraudulent purpose in mind. And I went to a seminar not so long ago where, the feds in every district are taking computer hacking, of course, very seriously. It's viewed as a national security risk, but it's also viewed as a great risk on American business and the ability to do business with security. They have designated now agents working full-time just on computer crimes. They've designated, even in this district and in the major district, assistant U.S. attorneys who spend all their time assigned to computer crime or computer hacking. I know who they are. They want everyone to know who they are. They will take phone calls. They're actually trying to invite public companies or private companies or anyone who has a problem to report and refer matters to them. They're waiting for the phones to ring. So, how are we in time? Pretty good, right? Yeah. I just wanted to raise a recent Ninth Circuit case in Nozal. It came out not even a month ago. But there was a split.
I don't want to do this, but feel free to say whatever you want.
Yeah, there was a split in circuits in whether inside employees could be charged under this Computer Fraud and Abuse Act as opposed to outside hackers. There was a very narrow definition of whether these employees could be exposed under it in the Fourth and Ninth Circuits. This circuit, which is the Seventh, always had a broad definition. Anyway, the Ninth Circuit basically says that even a former employee who then gets access to their former employer's computer system and uses it without authorization can and should be charged under the Computer Fraud and Abuse Act. So the takeaways here from my point of view is the CFAA is a big stick, and it's one that companies could use and should be aware of against employees or outside hackers or former employees who use the computers for improper purposes or unauthorized access. It applies to, I think it overlaps with those cases where sometimes a former employee will leave the company after downloading information or proprietary information on the employer system that they didn't have authorization to take or use with them post-employment. So it dovetails into that too.
Do you want to talk a little bit about the penalty?
Well, the penalties, yeah, I mean, really quickly, as I said, the statute serves two purposes, civil and criminal. It's a criminal felony statute. It has severe penalties. The feds are very interested. They're hot to trot to go on more computer crime acts and cases. And they've designated, as I said, more resources to it, at least under this administration. I realize every administration differs, especially with the Department of Justice and what they put their focal points on. But again, what you should know, I think practically speaking, are the civil penalties and civil causes of action. They can be brought. Loss of even business goodwill can constitute loss or damage. You don't always have to quantify it in terms of money out of the pocket. Out-of-pocket loss is not necessary to show damage here. It's enough to show reputational loss. It's enough to show goodwill. And what I've mentioned before is it's extraterritorial. It can be applied and has been applied to outside hackers. You might wonder, what's the practical effect of that? Who cares if you indict some guy in Uzbekistan who's hacked your computer? Well, it's interesting because I've actually used to have, the practical impact is that in this day and age, when the people don't show up into the US courts, there's a warrant for their arrest issued because of the non-show. That warrant gets on the international Interpol computers. That's what everyone is checking when they're checking your passport when you're traveling in any country. It's going into an Interpol computer. That's what state police are checking when they're checking your driver's license. It doesn't just go into an Illinois state computer, it goes into a national criminal computer database. So it's fine, you can hack computer, but if you're going to do it from Uzbekistan, you better stay there, because the minute you go to Germany, or if you're going to Poland or New York, you will be arrested on the border.
So we talked a little bit about what the exposure is and what the danger is. And I think we failed to mention that aside from the federal court class actions that have been happening, there's a lot of state privacy laws that are being implicated by classes. So aside from litigation in that, for instance, that Neiman Marcus case, there have been people going to state court to bring class actions against companies to prosecute them for exposing their private information. So what, with all of that out there, what do you do about it? And kind of taking a cue from what Rachel was saying during the prior presentation, it's sometimes nice to say to people, here's how we can get out in front of it and try and avoid the whole mess. So the things that people should be doing is getting their hands around what their situation is. And that starts with technology, policies, procedures, and culture. Now, with the technology, what people need to have is a data map. They need to know where their sensitive information is. They need to know what computers, drives are actually occupied with that information. They need to know how people access it, and they need to know how to shut down access. They need to know when people are accessing information via their cell phones, laptops, desktop computers. So that type of a map is a cornerstone to the beginning of understanding how you're going to control your protection against cyber attacks. An important item to have in place as well is an incident response plan. And this is just going to be several steps that are required to be taken whenever an incident occurs. And part of that incident response plan goes back to what I was mentioning earlier. Is it an incident? Is it a breach? So the first thing that people are going to do is determine, did I have a breach? And if I had a breach, then you have to go down the rabbit hole of, do I need to notify the government? Do I need to put out some kind of notice to all the users? If I'm a person who deals in payment systems, do I need to get creditor monitoring up and going for the people who are exposed? All of that kind of stuff. And the cornerstone of any response plan is going to be having a response team in place. And the way you get this into the culture is to actually drill these things. So you put together fake breaches and you actually run through and make sure that everybody knows how to tick down the to-do list, who the person is who's likely either a lawyer or a risk manager in that path who's going to say, we need to get to the notification process, but having the plan in place makes it so that nobody needs to think about it when it happens. Some tips as to how to focus on avoiding additional exposure of private information is actually very similar to stuff that we talk about as tips as to how to protect your trade secrets. Don't keep sensitive information that you don't need. So if you're collecting data on your employees or on your customers and you don't need a social security number, don't take a social security number. If you need it for one purpose, keep it in that place. Don't populate a whole bunch of other documents in your systems with it. Restrict access to sensitive data. Only let those people who actually need to get to the stuff, get to the stuff. And you can do this mostly with computers and logins, and most people should be maintaining actually a computer. If you're a sophisticated company and not just like a handful of people shop, your computer system should be segmented such that there are regions of the computer system that you can access and others that you cannot. Or that can be accessed from the external that cannot. For instance, at Freeborn and Peters, all of the client-sensitive documents we collect in cases resides on a particular drive. We have a server that we put all that stuff on. And that can only be accessed either from your desktop at the office or from your VPN, your virtual personal network login from outside the office. And that's on purpose. We've also shut down access to USB drives on computers. You can let people access things through the USB drive, but you have to track it. Require password authentication. For instance, if people are having laptops, how many people here have their laptop password, just the password turned on? Okay. Those who didn't raise your hand, turn the password on. You may also need to take the step of encrypting areas of your laptop where you keep sensitive data for your work purposes. If you use USB drives, you're going to want to take steps to either encrypt those, lock those. You don't want to leave it on the seat of a cab and let somebody run off with important data. These are some resources that are in one of the slides. All of these entities have very well developed cyber-related data. I'm only going to mention a couple. You should be able to get a Google search to any of these, or Bing, whatever. I don't want to be but I will mention the National Institute of Standards and Technology as part of the Department of Commerce. Their framework for cybersecurity is one that is looked to by many in the industry as kind of the gold standard. If you're in California, they require you to look at SANS. But I think most people can use National Institute of Standards and Technology as a good primer on what is expected of companies. And for personal use, that Cybersecurity Alliance is useful because it's got great educational materials for kids and how to be sort of accessing the digital world. They have educational materials at like sort of every age level. So that's a useful one. The others all have good data that's worth accessing. So these are some of the particular kinds of dangers that people should be training to avoid. Everybody know what phishing is? So the reason I bring it up is if people are not training their people to understand that suspicious emails should not be opened, and particularly not that weird-looking attachment you've never seen the ending on before, they should be. The CEO fraud one is a good one. If sometimes the CEO will get an email that says, I have not been paid on this, pay me now. And it looks like a regular vendor, and they have an invoice, so he sends that off to the CFO, and the CFO sees the CEO send him an email, and they go, oh my God, I gotta pay this right now because the CEO told me to pay it. Well, that wasn't a real invoice. That was something made up by somebody. So I only say that so that, if you're talking to a CEO, you might wanna tell them, you should make sure before you send stuff off. I know that can be a sensitive conversation though. On social media, people should be told not to post things that are sensitive. And people should also be trained to understand that they shouldn't be posting sensitive personal information of their own even. Finally, I'd point out some best practices on smartphones, USB drives, and laptops. Encrypt these, have them controllable from remote locations so that your IT professionals can shut them down when people lose them or get them stolen. I do want to spend some time talking a little bit about insurance considerations relating to cybersecurity. This is a relatively new subject matter area for insurance. And therefore, there's coverage litigation happening quite a bit now. Most insurance companies are taking relatively aggressive positions that the traditional commercial general liability policy or a directors and officers liability policy, directors and officers acts and omissions policy, does not cover cybersecurity related issues. There are arguments to be made, and I mainly point this out to say that the insurance questions are something that should be addressed when you find out that you're subject to either a breach or litigation. And you're going to need to sit down with your policy and to look at exactly what it says. If it's an old policy that doesn't have an express exclusion, because new policies are going to have it, and if you don't have one yet, the next time you go in to renew your policy, they're going to throw one on there. You might have an argument under your existing policy. But there are cybersecurity related insurance policies that are available, and your local broker or insurance company will be happy to sell them to you. Some of the things that you're going to want to be looking for in those policies include coverage for forensic costs. So if you need to go back and determine how the breach occurred and who was at risk or who is at fault. Regulatory action, if you have to deal with all those notification issues that I was talking about before, you want coverage for that cost. If you're in the payment card industry, you're going to want coverage for the fines and penalties and the related credit monitoring. What about a business interruption policy or endorsement that rides along with your policy? So the insurance issue is a big one, but we are now not good on time anymore. So I'm going to jump ahead to try and cover the last bit, which is arbitration provisions. I will say that when Alex and I sat down to do our hot topics, we were originally going to do a full hour on the amendments to the federal rules. We decided that wasn't fair to us or you. So that's how we got in. These are unrelated, but all kind of important things. And the arbitration thing, the main thing I want to focus on is there have been a couple of interesting new developments in arbitration law and how courts are interpreting and enforcing arbitration provisions. First, I don't want to spend a ton of time in the on background. We know arbitration is a private agreement to deal with a dispute outside of the courts. And I did want to kind of check with the people here today who get to make the call as to whether you're going to use arbitration or not. Show of hands, who likes arbitration? Who does not? Who likes it sometimes but not others? All right. So if you go through the room, I would say it's about a third, a third, a third. And that is because there are many different issues that have been run into. Sometimes you get an arbitrator who likes to split the baby. Sometimes you have courts that take forever to get a resolution and make odd decisions. So do arbitrators. So there, as arbitration applies, it's really up to the person entering into the agreements whether you want to include arbitration provisions in your agreements. Since we are getting low, I'm not going to go through all of what we got to, but the background of arbitration law these days has been a parade of the court saying arbitration provisions are enforceable. And that started back with, well, it was really made clear in prima paint with the Supreme Court saying we want to favor these things. And then as we go through the cases most people know, which are things like AT&T versus Concepcion, this American Express versus Italian Colors Restaurants, and I'll focus on AT&T versus Concepcion for a second. This is the case that said it's okay to include an arbitration provision in your agreement you sign when you go and get your AT&T phone. So you go in there, they have an arbitration provision, and it says on the agreement, AT&T can unilaterally amend this at any time, and you sign it to get your phone. Well, Mr. Concepcion was unhappy that he had to pay the sales tax when he got his free phone and wanted to join a class of people to get that sales tax back. When they did that, they implicated the arbitration provision in AT&T's contract, but the court said, and he said, no way, this is a class action, I'm trying to defend my rights. The Supreme Court didn't agree. They said that the arbitration provision is perfectly enforceable and went ahead and allowed AT&T to enforce it. Some people saw that getting on the edge of sort of fairness to the consumer. But it has been expanded even further into class action lawsuits in another case that's cited back here. I'm sorry, personal injury suits. So personal injury, you can be required to arbitrate. There's no way you knew you were going to get injured, and there's no way you're signing away your right to be injured, but you can sign away your right to trial on that injury. So the main point I wanted to get to is this Seventh Circuit case at the end, Lewis versus Epic Systems. What had occurred recently was that more and more cases were saying that employment class actions can be signed away in an arbitration provision as well. So collective and class actions were no longer a substantive right, and in the D.H. Horton versus NLRB case that's cited there, the Fifth Circuit said, you know, we hear what you're saying on NLRB, but these individuals, they signed away their right to a collective action. That's not at odds with the National Labor Relations Act, which requires the right to bring a class. And they said that the Federal Arbitration Act trumps the NLRA's provision for class actions. The Seventh Circuit, yeah.
I'm sorry, go ahead.
Yeah. The Seventh Circuit is the first circuit that said no, after a series of the circuits throughout the country had said that you can use arbitration provision. The Seventh Circuit found that the NLRA right to a collective action is a substantive right, and therefore the NLRA right trumps the Federal Arbitration Act. And in fact, the way they found they're consistent is because there's a savings clause at the end of the Federal Arbitration Act that said you can't use arbitration in any instance that's illegal. And they said, well, this is illegal because it violates the NLRA. That split is where it sits as of May.
2 quick points. We have 2 minutes. Let me make it really quick about arbitration. One is, regardless of what you think of arbitration, I think the first consideration should be, are you dealing with a domestic or multinational contract? If you're dealing with foreign parties in a contractual basis, they're overseas, that may be a very compelling reason to include an arbitration clause. My example, do you want to litigate in Uzbekistan? I don't think so. But do you want to arbitrate a dispute with an Uzbekistan party in London or New York? I think so. So I often advise clients, depending on what the nature of the contract is it international or is it domestic? More compelling reasons to go to international arbitration with multinational parties. Number two, David's point is a very hot topic. Can you give up your rights to a class action through an arbitration clause? The courts have been going a little back and forth on that. Judge Rakoff, a very independent judge in New York, I think Southern District or Eastern District, addressed Uber, and Uber has some binding boilerplate clause on some part of its website that you never see and you will never read, saying you're going to arbitration if you get into a dispute with Uber. He said that's illegal. You can't do that. That's sort of an adhesion clause. So they're undercutting some of these arbitration clauses when they appear on page 10 of a website you never read.
And on that one, actually, Judge Rakoff spent many pages of the decision going through every type of click wrap agreement you could have. Is it the one that you click the box and then push enter? Is it the one that just goes in? And it was, the real substance of that was whether or not you had actually agreed, because Judge Rakoff was focusing on whether you could agree to something you never saw.
Thanks very much, and we can now take questions, or we can take them during the break, but thank you very much.